Time, so we'll go ahead and get started today. I want to welcome you all to one of the Office of Equity and Inclusion Lunch and Learn sessions. This session is entitled Divisive Concepts, but obviously there are going to be other things that we'll talk about today. The style of this particular Lunch and Learn is a little bit different from the ones we've had in the past. This time we're going to have some interaction by Mark Folks, who's the general counsel for ETSU, and of course, Brian Lapps, who's general counsel for TBR. So they're going to have some conversation regarding divisive concepts, among other important legislature that has been coming forward, or the potential of some things that could potentially come forward. And so again, I'm going to turn it over to Mark, and he will get us started.
Yeah, so good afternoon. We would like to welcome you as well. It is my pleasure I've spoken with you all with Lunch and Learn for Dr. Johnson before. It's good to be invited back. That means I wasn't a total bomb the last time. But this time we've brought in the real showman, Brian Lapps, who is the general counsel at the Board of Regents. And Dr. Johnson has just asked us to talk about diversity, equity, and divisive concepts, which we've had a lot of movement on with some new statutes enacted last year, and we've got one pending this year. So we're going to talk about that. And just a couple of, or at least one quick caveat, we will do our best to answer any questions. That's what we are, I think, both primarily interested in doing. We are going to handle this as kind of a discussion between Brian and I, and we will monitor the chat box. So if you have a question, you can put it in there, and we will incorporate that into our discussion. And the other thing is, we generally will be talking a lot about law and answering your questions, but we want to, I guess, advise you all not to take anything that we say today as, hard and fast legal advice. For legal advice, we probably will have to delve into the facts of whatever situation that you're asking us about in far greater detail than we have time to get into today. But we will entertain those questions as best as we can based on the time that we have, and treating them as hypothetical scenarios rather than real life scenarios. And then any actual legal advice that you may need, you can run that through my office later. We will be happy to help you with that. So Brian, to get things started off, why don't you just give the folks a brief introduction of yourself and who you are, where you've been, and what you do currently.
All right. Well, thank you, Mark. I appreciate that. And Dr. Johnson, I appreciate the invitation. It's I used to tell people it's good to get out of the office and see people and do these speaking engagements. Now half of them seem to be sitting in my office doing these speaking engagements, but nonetheless, it's good to get out and do something a little bit different. And like Mark said, not only is this not legal advice, I don't represent ETSU, so nothing I say is clearly legal advice. And anything you should take. What I'm going to say today is probably worth the price of admission. So keep that in mind as well. I've been here at the TBR almost 3 years. It'll be 3 years on July 1. Before that, a couple of years, I was at the Vanderbilt University Medical Center, where I had kind of 1 foot in higher ed and 1 foot in an academic medical center. Prior to that, 9.5 years at the University of Tennessee in their general counsel's office. And then I was in private practice doing primarily labor and employment law at a large Nashville firm. So I've been dealing with people problems for the vast majority of my career, with some detours and branching out along the way. But I'm certainly enjoying being back in higher ed and working with the community colleges and technical colleges now.
Okay, thanks, Brian. We'll go ahead and just dive right in now, I guess, and get the ball rolling with divisive concepts. What are your general thoughts on that subject as words of wisdom that you can provide just generally?
Yeah, generally, and many of you on this call probably have been paying attention to this subject, and this is not your first time through. So I'll just go through and just kind of give an overview of what was passed last year, and then we can just kind of have a discussion. And like Mark said, rather than engaging in some kind of lecture format, I much prefer kind of a question and answer type thing. So feel free to ask questions as we go along. But last year, the General Assembly took and expanded what was a divisive concepts bill aimed at K through 12 education and made it apply to higher education. There's some important differences between the K through 12 version and the higher ed version, but the basics are, and when I talk about this, people hear the term divisive concepts and they say, what does that mean? And I can say, well, the good thing about this statute is divisive concepts is a defined term. Certainly lots of things in our politics nowadays are divisive. Many of them are even concepts. But the divisive concepts that we're talking about today and that are part of Tennessee law is a list of 16 things that are specifically defined by statute, largely dealing with race and sex and political hot button terms of that nature. There are things, and again, I'm guessing that many people on this, if not most people, are faculty, but I don't know the names, so I don't know for sure, as opposed to administration. But for those of you who are faculty, these 16 things are probably things you don't teach. Even if you're in poli-sci, you're probably not teaching these in any kind of depth. You may refer to them and mention them as current events, but I've yet to find anybody who's really, at least at the TBR, actually saying, oh, now that I understand what they are, I'm still really concerned that I might be teaching something in violation of it. And when they do say that, I say, well, the second good thing for you is that it doesn't limit what you can teach. In the K through 12 sphere, there's some limitations on whether these divisive concepts can be taught. At the higher ed level, there is no prohibition on teaching them. Rather, the legislature has recognized that the First Amendment applies and has recognized that faculty have academic freedom and has not tried to say that you can't teach it. So what they've said, though, is that a student or employee of a public institution of higher education shall not be penalized, discriminated against, or receive any adverse treatment due to the student's or employee's refusal to support, believe, endorse, embrace, confess, act upon, or otherwise assent to one or more of the divisive concepts. So in other words, you can't make people believe something or tell you that they believe something. So, I think most people in higher ed are not in the business of indoctrination, but they're rather in the business of trying to get people to think for themselves. So even discussing these divisive concepts, if you're going forward and getting people to think for themselves, is not a huge, in my mind, worry that anybody is going to find that you somehow were to have violated one of the divisive concepts. And importantly, this statute does not purport or try to overrule the Campus Free Speech Protection Act, which was passed several years ago by the Tennessee General Assembly. And it's part of your policy, it's on your website. And one of the things that the Campus Free Speech Protection Act, which I think is verbatim in your policy, says that no faculty will face adverse employment action for classroom speech unless it is not reasonably germane to the subject matter of the class as broadly construed and comprises a substantial portion of classroom instruction. So I think the General Assembly, while they certainly had goals on making some statements, did recognize that the First Amendment applies, especially in the higher ed space as it pertains to faculty. So again, there are some other portions of it, but I think those are kind of the big things. Mark, what did I leave out?
I think you covered everything pretty well there. I did have, one point that I wanted to see if you could elaborate on, because you used the phrase defined term. And for you and me, we're used to referring to things in that context. You might explain to them
Yeah.
a little more the legal significance of what it means to have a defined term.
All right. Well, again, when you're passing legislation, there are often definitions, and we lawyers refer to them as defined terms. So the legislation defines divisive concept as 16 things. For example, it says divisive concept means a concept that, and then it lists A through whatever the 16th letter of the alphabet is. And it's, for example, one race or sex is inherently superior or inferior to another. An individual, by virtue of race or sex, is inherently privileged, racist, sexist, or oppressive, whether consciously or subconsciously. And again, that can be taught. You just can't require people to adhere to that. So by defined terms, and that's what it means. It is that you just can't wonder, is something a divisive concept? For example, whether handguns should be regulated more closely or assault rifles should be regulated more closely is clearly divisive, and it's clearly a concept, but it's not part of this statute as a divisive concept.
Yeah. So and just so you're aware of this, Brian, and the other people are watching are aware of this as well. We have had we do have some departments that touch on some of these concepts, and even in some of them where they are required by accreditation standards and things of that nature. So when I'm advising people, and this, so all of you watching will know what I'm going to be doing if you pose a question, is I'm going to get that statute of the divisive concepts, and I'm going to look at how it's defined. And I've had some departments do this, I'm going to say, send me your accreditation standard. And often, the divisive concept is written a little more strictly or stringently or more specifically than what the accreditation standards are. So that's why the defined terms part is important, because I look at it and go, it has to fit that definition and what the General Assembly is after. So it's not necessarily a problem just to teach these concepts or to teach particular theories that would appear to be related, whether it's, critical race theory is one of the big ones, or any sort of related theory to that. It doesn't ban the teaching of that. It bans trying to coerce people into believing that, and forcing them to acknowledge things, or you can think of trying to force somebody to swear an oath. That is something, as it works out as a practical matter, particularly when we see some of this in the College of Medicine and in nursing and some of those areas that do clinicals, where they're taught a lot of race sensitivity, more on the lines of diversity, equity, inclusion than the divisive concepts, but they're so closely related. We often get questions about that. And, we look at the definition and say, well, is this exactly these words? Is this what you're doing? Well, no, but we're close to it, because there's always a dividing line. And legally, you can go right up to the line. You just can't cross the line. And sometimes that looks like a clever trick to some people, but you can think of it as the solid yellow line in the middle of the road. That means you don't cross it. You don't, pass there. It works the same way. So as we're working out those questions, you can do that yourself before you call and look at it and see, does it really fit the definition? Or am I operating in an open area that's a little more permissible? So, and as Brian said, you also do have those who are tenured or protected by tenure. And then the act itself says, or the Campus Free Speech Protection Act says you're not allowed to be punished for things that you do in the classroom. So there, and this act itself says it has to be a substantial portion and not reasonably related and things like that. So there are a whole lot of protections, and you really, in my view, have to go to somewhat of an extreme level before this is going to impact the classroom in particular. So do you have any follow-up on those comments, Brian?
I'm just, just to follow up, one of the things I was asked previously, dealt with testing is, well, if I ask things on tests, might I run afoul of it? And my answer was, well, if you ask questions in a certain way, you're much less likely to be challenged than if you ask them in another way. For example, if you're doing a true false test or a multiple choice, you might say, a critical race theorist would say the following, true or false, or which of the following might a critical race theorist say, and check all that apply. That's different than saying, true or false, I'll say, white people are inherent oppressors, true or false. That might be, that's not something I would recommend testing on. Whereas you could say, a critical race theorist would say that true, and then true or false. And again, that way you're not requiring anybody to believe anything. You're just testing the subject matter. If you're a math teacher, that's probably not even relevant to the subject. But if you're teaching political science or a related field, that might be a way to address those, is one of the questions I've been asked before and how I've answered that.
Yeah, and I think that's a great point, and relating it back to the clinical experiences that we've had and the accreditation standards that I've looked at. It says usually they're written in terms of, to earn the degree, a person has to demonstrate competency in, and it will then list a particular area, and it is usually something related to maybe one of the principles of the critical race theory, or related to one of the things listed in our divisive concept statute. And demonstrating competency in that is different than swearing allegiance to it or believing it. And one of the examples that I've used in discussing this before is, and Brian keeps mentioning political science. Was my first foray into graduate school, and I studied political theory. I took a class on Marxism. I'm probably about the furthest thing you'll ever meet to a Marxist, but I demonstrated my competency in Marxist theory without having to swear allegiance to it or believe that it was actually true or anything like that. So you can do that in any academic discipline that we have. I don't have a person, and to relate it to a controversy that's currently going on and we've all been hearing about in the media for the past couple of years, is somebody may not believe that a vaccine is safe and effective. That doesn't mean they can't demonstrate competency in the field of vaccinations and how they work, how they're created, what they're designed to do, and how to evaluate the science and stuff of their safety and stuff. They don't have to believe one is true. They don't have to believe that principle to demonstrate competency in it. And that's the kind of thing that I've seen in the accreditation standards. It's the same, as Brian said, in the classroom. You don't have to affirm it to test somebody, ask them to affirm the truthfulness of something. You can couch it in terms of what's the theory, what's the belief system, what's the hypothesis or the facts or whatever, to handle it along those lines. So any follow-up on that, Brian?
No, I just want to, if I could segue into one slightly different point, but I don't have any more follow-up on that.
Go right ahead.
And that point is, this has now been on the books for, I think it was passed right around a year ago. It became effective July 1 of 22. So it's been effective for almost, well, for 9 months essentially now. And I think there was a lot of concern about it when it was passed. What does it mean? How do we deal with it? How do we comply with it? But I haven't heard any real issues in compliance with it, or any, nothing has made it to me that somebody has been, students are claiming that they're being required to adhere to anything, or that there's been a violation of the act. And Mark, I don't know whether you've heard anything on that stance either. So it seems from my perspective that it may largely be a statement that our legislature has been made, but has it really, and maybe it's changed some behavior, but is it a big statute to worry about violating? I haven't seen evidence of that.
We have not, we haven't had any, I think, formal complaints. I think a lot of the questions, and I haven't even really, to be honest with you, received a whole lot of questions on the topic, but it seems like some of the questions that we have received were people trying to figure out that, well, something happened in class. How does this law, and that may be their hypothetical, and how does that apply? And when we explain it, whether it's a faculty member or a student or whomever, they realize, okay, that didn't cross the line then. But we have not had any formal complaints. We have not found any violations. I am not aware of any either, just because I think once the word is out about where the dividing line is, I think generally speaking, these are things that either we weren't doing them, or if we were doing them, people changed the way they teach, or maybe they're, preaching to the choir, so to speak, such that their classes don't complain. So if I'm checking the chat message. I've got one question in there. So I thought if we're ready, I can bring this up. And I think it's an excellent point that we've been talking a lot so far about mostly as it applies to faculty, but we do also have some administrators and some staff members on the call with us today as well. Can you talk about what protection, how does it apply to staff members? And what protections do administrators and staff members have?
Sure. And the same divisive concepts apply to faculty as they do staff. Obviously, staff aren't in a teaching role. I mean, I guess somebody like Mark is staff and he's also faculty, so he engages in a teaching role. But in a staff role, where it's more likely to come up is making an employment decision. And as I read previously, it's unlawful to require either an employee or a student to adhere to something like that, to adhere to one of the divisive concepts. So if a supervisor were conditioning promotion on adherence to a divisive concept, that would be problematic. And the statute also has a slightly separate provision, has a provision in addition to what I just said, that says that a student or employee of a public institution of higher education shall not be required to endorse a specific ideology or political viewpoint to be eligible for hiring, tenure, promotion, graduation, etc. So again, don't do that. And then one of the ones that's perhaps I consider a potential trap for the unwary would be that institutions are not permitted to ask the ideological or political viewpoint of a student or job applicant or job candidate for hiring or promotion, including for tenure. So getting too far into it. So that's kind of a trap for the unwary, I think, because sometimes, especially on different fields and whatnot, you might venture into political viewpoints and things like that. I think at least most hiring processes that I've seen into or been part of have avoided that. They may talk about the ability to deal with our legislature or the ability to understand different viewpoints and things like that in politics. But again, the political litmus test, so to speak, is something that the Divisive Concepts bill will prohibit. And as far as protection, did you want me to get into legal protections as well? Is that what
well,
you meant, protections, or?
let me ask a follow-up question there. That then this is a question that occurred to me while you were explaining that. But so either the act that we're talking about or one of the related ones also requires the university to ensure intellectual diversity. If we're not allowed to inquire people of their political beliefs or their intellectual bent in hiring, how do we go about implement or ensuring intellectual diversity in hiring? Or, what are your thoughts on that? Does it apply in the employment context or just the invited speakers context?
Well, I think it does. I'm trying to think. I don't think the Divisive Concepts bill actually says that you have to hire people of diverse viewpoints. I think it says you can't discriminate against them. I interpret that to mean you can't discriminate against based on viewpoints. And some of the language does require, that's why we're doing an intellectual diversity survey in part, is to determine the existence of different viewpoints on different topics, et cetera, et cetera. And I can get into House Bill 1376 here in a little bit that does talk about what are requirements if your job includes DEI. Is that what you're asking about, Mark, or am I not understanding correctly?
Well, yeah, I mean, it was just a thought that popped into my head, so I may have been completely off the wall, which those who know me here will not be surprised at all to see. But following up then, I think two quick things is I got a follow-up question as well. And the important thing for our administrators and staff is that a lot of them are involved and I'll give a little bit of background because you all may not do the same stuff at TBR. But so our folks in student life and enrollment work with student groups that do a lot of programming, and sometimes that is jointly sponsored with a student group and student life, or maybe another department on in the university itself. We do the professional development training and programming that often touches on related concepts. So in those types of concepts, or with the basically training, like, we do CLEs, our administrators and staff do basically professional development. How does this apply in that context to our staff and administrators?
Yeah, well, in last year's bill, it's one of the more vague. It's one of the things that I think has been something that our people have worked on, which is that a public institution of education shall not conduct any mandatory training of students or employees if it includes one or more divisive concepts. And it also says that public institutions of higher education shall not use training programs or training materials for students or employees if they include one or more of the divisive concepts. So some of the training issues are, we can still have training on it, but it's become more difficult to have any kind of required training or mandatory training, and if it includes one of those divisive concepts. But again, like I said, most of those things are not really what you're going to train people. Training people that the rule of law doesn't apply and it's all a power relationship. You can put that in the classroom context, but I'm not sure what real applicability that would have in the staff context or the employment context, that the rule that doesn't apply. So again, many of these things don't apply. And the way we've done it, kind of operationalized it here, is that if you're bringing in a trainer that, I mean, first of all, our contracts for speakers and things like that have some boilerplate language saying, please, essentially, please comply with Tennessee Code annotated 49.7/1901 et cetera, or whatever it is. And, we expect you to do that. So we've got that in there. And then if we tell our people, if you see something in there, compare it to the divisive concepts list. And if you still have questions, you can talk to the counsel assigned to your campus. Again, we were concerned as lawyers that we just don't have the bandwidth to review every training to see if there's something that's possibly a divisive concept in there. But if you think after you have looked through it and studied the issue that you still have questions, we can help you on that one. And I think that process seems to be working. At least I haven't had complaints about it or negative observations about it. And so it seems to be working. I'll take silence as good news from that standpoint.
Yeah, and I think we've taken a similar approach with invited speakers, at least in some instances, but also we just generally advise people to steer clear of mandatory trainings. If it's not mandatory, then the speaker and the program director and the department and whomever has a broader range of ability to address things as they see fit within their managerial discretion.
And we certainly have speakers too, not as many as the universities have. And our events tend to be lower. Our potentially controversial events tend to be lower profile than some of the universities, and that makes my job a little bit easier probably. But there's certainly the potential for that. But then we have to recognize that it also depends on who is putting on the event. Is it the university or the college putting on the event and speaking, or is it a student group putting it on and speaking? Very different, very different situations there from a First Amendment standpoint.
Another part of the same question was I guess more towards the practical application of how to be mindful managers or leaders if we're prohibited from the divisive concepts. And I think we both kind of already touched on that, as it's largely a matter of degree that for, say, diversity, equity, and inclusion purposes and managing and it's okay to understand that people have different backgrounds and they have different, may come from different cultures and have different expectations and those types of things. And the best way that I think that you can be a better or a more mindful manager is to get to know the people that you're managing. What are their beliefs and understandings in certain contextual circumstances. I think that's how you're more mindful. But I also think, to be more mindful, you kind of have to see both sides of some things. And the divisive concepts are considered divisive because the General Assembly believes that if you act on these things in the workplace, it's going to pit one group or one person against another person along race, gender, primarily race or gender lines. So in managing, it's, in my experience, often difficult to do some of those things because particularly if you are dealing with people who come from polar opposites on an ideological spectrum or a religious spectrum or the political spectrum, you kind of have to bring people together and say, learn how to get along, and the manager has to understand how to get those people on mission or on task despite various differences. And one of the areas we have seen that play out, it hasn't become a major issue, but we've had some minor issues with some athletics teams where One was pushing, I think in one instance, it was a religious issue. And I think in another instance, it was a political issue where members of a particular team were trying to force their teammates to sorry, a note just popped up. It got me distracted. I said sex and gender, but sex and race. I meant sex and race. If I said sex and gender, I apologize. It is race and sex is what the divisive concepts are primarily geared at. But we have had those instances where, you know, religious differences and political differences have played out. And that's where, you know, it can be difficult, but you've got to, you know, find a way to get your team to come together and realize that, you know, while your teammates, you know, the mission is to go out and win ball games. When your teammates, like in my department in legal, it's me trying to, despite our differences, and we have some internally, you know, set political beliefs and social beliefs and religious beliefs aside and realize we have to work together to guide the university on legal matters. So, and my approach in that regard is usually try to, you know, focus on the positive and focus on the common goals and the common shared experiences, and hopefully build a foundation based on that. Let me see what else we've covered. There's still some questions in there. Well, let's go back quickly to the issue of legal protections for administrators and staff in this context. If there's a complaint that this law has been violated, how does that play out?
I'll say first that this law does not contemplate lawsuits against individual employees, whether they be faculty or staff. It contemplates a lawsuit against the institution. So I have yet to think of what would be a viable lawsuit against an individual faculty member or staff member. I suppose one could come up. I mean, again, anybody can be sued for anything. I get that. I recognize that, but it really focuses lawsuits against the institution, not individuals. Second of all, there are state employee liability protections that basically say if you're doing something that's within the scope of your job duties and it's not criminal, willful for personal gain, then you have protections on there. I'll say that I don't view this as a place where faculty members are likely to get sued in their individual capacities. And it would seem to me that the legal protections that are existing in state law would apply. I don't know, Mark, whether ETSU has them summarized, but I know that the University of Tennessee does because I helped revise them. And I know that the Tennessee Board of Regents does because I with University of Tennessee's permission, used them and made some slight modifications for our context. But on either the UT General Counsel website or the TBR website, if there's not one on the ETSU website, there's a statement of protections for individual employees. And those are really based on state law concepts. And it just explains, what kind of immunities you have, and they're pretty broad, and what to do if you get sued and how those kinds of things work. It's pretty down in the weeds and technical, but I haven't counseled anybody that they need to worry about their house or their cars or anything from potential liability if they were to get sued on this type stuff. Again, if you're acting in good faith and working in good faith and not trying to tell people you must believe these things, it seems like it's more theoretical liability. And again, I get why people would be worried. I'm not trying to downplay concerns. I'm just saying that in my professional capacity, it's not one of the legal issues that I worry about employees getting in trouble with most, as compared to some of the First Amendment issues that employees might get tangled up in, or some violations of due process in disciplinary matters or sexual misconduct matters. I worry far more about those types of issues than divisive concepts issues.
Gotcha. And so, first of all, I want to thank you for giving me a homework assignment there that you probably didn't realize you were giving me, but I do not believe that I have a statement of protections on my website. So I will probably be contacting you and UT for permission to borrow from your website to get that up on mine, because it is a bit of advice that I haven't had to answer that question a lot, but I have answered the question. And to put it in more practical terms, as Brian said, if you're operating within the scope of your employment, then the university is going to, or is most often required to represent you. We do that by through the Attorney General's office. We do, we have had people, sometimes lawyers will put an individual's name on a lawsuit, even if they sue you or try to sue an employee individually. A lot of times the lawsuit will say, I'm suing Mark Folks individually and in his official capacity. In those types of cases, it is, I don't want to speak too far out of turn, because it is the Attorney General's decision. But as long as the university's on your side and the Attorney General agrees that whatever decision was made was within your employment or managerial discretion, you're going to have protection, meaning the Attorney General's office represents you. And generally speaking, any judgment, if it is against there, would be paid out of the state's risk management fund. In the medical context, we see some malpractice claims occasionally. A lot of the claims that we've seen go through straight up through the Claims Commission. So at least to my knowledge here, we haven't ever had anybody held personally responsible for something that they did within the scope of their employment. You really kind of have to go to extremely out of your assigned duties for that to happen. So that's how it works as a practical matter. And let me look at, if you have something to say, Brian, I'm gonna read these, following up on that, I'm gonna read these questions.
Yeah, I'll follow up on that last point while you're looking for another question, Mark, and just say, where Mark says he's not aware of any individual employees being liable, I'm not either, with one exception. And I'm saying both at my time at my 2.5 years at TBR, as well as my 9.5 years at UT, plus the knowledge of the general counsel of UT, whose knowledge I think went back at the time to 1978 or so. There was only one situation that we knew of where an individual was not afforded the protections by the Attorney General and was potentially liable. And that involved somebody who was in residence at a college, had a handgun in violation of college policy, the law, had somebody over, was drinking in violation of college policy, and there was an accident with the firearm, and that was not one. So that's the kind of example I give for what you have to be doing, what I have seen you have to be doing in order to not get those protections, is how I phrase that.
Yeah, I think that is a great example. And I will add to my experience here. I was in the Attorney General's office for 12.5 years. And even in that time, I didn't hear of anybody losing civil protection. But the example that you use is a prime one. If our policies, rules and policies are designed to establish the parameters of employment. So if you're operating within those or within the realm of reasonable mistakes, you're fine. The circumstances that Brian described, where you're talking about a violation of firearms laws and drinking, and that would go beyond the scope of employment. So That to me is the type of extreme, or demonstrates how extreme that has to be. And I say that both as a drinker and a gun owner, that, yeah, those things are outside the scope of employment. So let's go now. There is a question here about the issue of if a faculty member requires students to attend a speaker event on divisive concepts that is on a topic that is directly related to the class subject matter.
Yeah, that's getting pretty close to looking at a very narrow legal advice, and that's something that I don't know that I can fully answer it, because it's going to depend on context. I think it's going to depend on details. My thought is, again, when you're in the faculty student context, are there legitimate pedagogical reasons to do it? Are you trying to acquire mastery of the subject matter? And, I can see where saying, well, I'm gonna go back to Marxism example. We've got a leading Marxist theorist coming in, perhaps, and I want you to go listen to that leading Marxist theorist in order to understand what they're teaching. I don't know that you're requiring somebody to believe it, and I don't know that that would be training, because it's really talking about employee training, and the definition of training in the statute includes seminars, workshops, trainings, and orientations. I interpret seminars to not be academic type of things. So I interpret those types of things to be outside the academic context. I don't know if that's the way you interpret it, Mark, which is probably more important to those on this call.
Yeah, well, I agree with everything you said there, particularly the part that gets really, really close to if somebody has a concern that's something that they're doing and they want to reach out to my office, we'll give you specific advice on the matter. But I do believe generally that if you're just saying, go listen to this lecture, in most circumstances, I think that's going to be fine. You could do the same thing by assigning a YouTube video or a TED talk by saying, I would relate it to if you're just related to those things. If you're just saying, go listen to this because it's very good on this theoretical point, and then incorporate that somehow into your learning, I think that's going to be fine. But we would want to probably address that as it's particularly implemented, just to be sure that we don't cross any lines.
And again, there's also the issue of legally speaking versus what is the perception of things. Again, I'm not a faculty member. That's your job, for those of you who are, to make those decisions. There can be obviously blowback from students, parents, the community, etc., when you do things that people don't like because they think it ought to be illegal. So y'all know that that's not legal advice. Even if I were giving legal advice, that wouldn't be legal advice. But recognize that there's more to this issue in society now than the legal issues. There are also the just how polarized we are as society issues that you can take into account, whether you want to or not. I mean, your decisions, again, not trying to indoctrinate you, just trying to lay the issues out there so you can make your own decisions.
All right, so there's another question asking if we can elaborate on faculty protections for those who are not tenured or tenure track. So we have lecturer positions, and I guess it says one of those involves divisive concepts areas. How vulnerable is that individual compared to a tenured or tenure track instructor?
Yeah, I think you need to answer that one, Mark, because I'm not familiar with your employment policies.
Well, so generally speaking, if that's what we're hiring them to teach, that's one aspect of it. But the same types of protections for the classroom are going to be there. That does touch on a First Amendment issue as well, as probably in the absence of tenure, then we're going to look at the First Amendment and academic freedom as being the protections that are afforded to those individuals. So if they are, particularly if they're teaching a class that we've hired them to teach, I would assume, and the university is generally on record of saying we're going to support any faculty member who is teaching this subject as long within the dictates of the statute, where it's related to the course, and that's what you're supposed to teach. It's in part of the curriculum. The university's not going to take action against that person, tenure track or not. But that for the primary, I think there would be, I guess, as I think about it, there would be two protections. If we hire them to teach a particular class, taking action against a person for doing what we hired them to do would be a breach of contract problem. But in this context of the classroom, it would also be potential First Amendment problems. Now, that is a very general response, again, as we've said a couple of times now, and hypothetical, because we could get into specifics where if the faculty member goes too far or goes beyond what we've actually hired them to do, they may not be in this context as equally protected as tenured and tenure track professors. But generally, there are other protections through our accrediting agencies as well. With if you're talking about a lecturer who's on a contract, we're generally supposed to give at least a year's notice before non-renewals and things of that nature. But those positions are different enough that I would really have to have a more specific question, and that's something that somebody can reach out to my office and we'll talk about. But I always, on things First Amendment, and anytime I talk about this, I say I'm pretty much a purist. I start from the proposition that everything is protected, and then I go to, is there an exception to the protection that applies? And those exceptions are few and far between. So when you're in the classroom, that First Amendment is going to protect any faculty member, tenured, untenured, guest speaker, adjunct, contractual lecturer, whatever you have, that First Amendment is going to provide a major protection. But if we need, so I guess the bottom line is, I don't think personally think they're any more vulnerable than a tenured faculty member for things that happen in the classroom. Again, because the First Amendment and academic freedom are going to protect that. Now, conduct outside the classroom, things of that nature, they have less protection. Behavioral issues, job performance issues, things of that nature.
So, Mark, I'm not getting the same questions you are, but I've gotten a couple of direct messages asking me to follow up on what I mentioned about another bill and whether there was another bill. So if I could go ahead and address that issue, unless you want to.
No, absolutely. Go right ahead.
All right. And the answer, like I said, just briefly, and then I got sidetracked. There is a bill out there right now, and I'll give you the numbers here in just a sec if you want to write them down. But what this bill does is it makes some changes to the Divisive Concepts statute. It's Senate Bill 817, House Bill 1376. If you go on the General Assembly's website to look for it, make sure you find the amendment, because that is what is likely to pass, my people tell me, not the original bill. It passed the House Government Operations yesterday, and it's headed to the Calendar and Rules Committee, which I understand is stopped before the floor and before the full House. And then it's on the Senate Education Committee for today. What it does is it does amend that same chapter of the code that contains the Divisive Concepts Act that's on the books now. it discusses some findings relating to the need for intellectual diversity. It then has some requirements that institutions of higher education follow First Amendment principles that I think we're already following in terms of invited, speakers invited by student groups, et cetera, not charging extra for security and things like that, that are pretty mainstream and pretty well understood First Amendment concepts. And then substantively, what it does is it permits students and employees to file internal complaints if they were penalized or required to adhere to a divisive concept, if they think that. So I think what, if this passes, we'll have to do is come up with a process for investigating those kind of complaints. I think there are probably different models to do it, but the model that we have, and I think you probably have something similar to, because it came over in 2016, 2017, and may still be there, is somebody does the investigation, makes findings and recommendations, then a more senior person looks at it and adopts it or not, and figures out what to do. So there's an internal complaint mechanism. Reports then need to be provided to the presidents of the institutions. There's a requirement in it that one cannot require any kind of personal diversity statement. These have been getting some publicity in recent years about, do you have to provide some kind of diversity statement? I think there's a concern that means you're essentially having to say that you do believe in something that you might not believe in order to get a job. So the legislature is looking to prohibit the use of those personal diversity statements. There is a travel fund limitation that we as institutions can't use funding if the organization it requires an individual or the individual's employer to endorse or promote a divisive concept. So I'm not exactly sure how broad that limitation would be, but if you're in the DEI space and you're looking to go, what I will advise my people probably if it passes is, if you're in the DEI area, pay attention to this and just make sure that that the organization isn't requiring adherence to it. And again, it just strikes me as something that's probably not happening, but obviously don't know everything that's happening out there. And then it also says that if an individual has a primary job title that includes diversity, equity, or inclusion, then that person's job duties must include efforts to strengthen and increase intellectual diversity and promote a climate facilitating free expression, not totally different than what's on the books currently, and then include efforts devoted to supporting student academic achievement or workforce readiness, mentoring, or something like that. So this is language that might change some job descriptions or job requirements. And one of the reasons I say, if you go on the legislator's website and look it up, make sure you look at the amendment, not the original, because the original had a much more prescriptive requirement, and that has been taken out of the legislation that's coming down the pike. And Mark, anything you want to add on that? Because I may have.
No, I think you covered it really well, and I see we've got like 2 minutes left, probably less than that. I just got another. Oh, nope, that was Kim's message to everybody. I thought that was another question I was going to try and squeeze in, but I will say, and I see Dr. Johnson's probably ready to draw us to a close. I'll say thanks for having us. Brian, thank you for coming as well. And with that, I'll turn it over to Dr. Johnson.
Well, thank you very much for inviting me.
Well, thanks, Brian and Mark, for this. This was great information for us. I want to make sure all of you all know that this has been recorded. What we will do, we'll post it. So if you want to go back and hear some of the responses to the questions, you'll be able to do that. But we'll make sure you're aware of the posting there. Also, Kim sent out a link to kind of the assessment of the session. Give us your feedback. Let us know, how you liked it. What we're trying to do is try to improve each one that we do. So I want to thank you for participating in today's Lunch and Learn. Please be on the lookout. We have many more to come. Definitely go back and look at the amendment for this particular divisive concepts bill, because it does have some implications there specifically for us who are in the DEI space, as well as many of you as well. So definitely do that. As Mark extended himself, if you have some additional questions or you're looking for some legal advice regarding this, please do reach out to him. Obviously, this is really good. I can almost envision as these laws are coming out of Nashville, we may have to have like a part 2 of this to explain some of the other kind of laws that's coming down. So Brian, Mark, thank you all. And for those who participated in today's Lunch and Learn, have a safe and wonderful afternoon. Take care.
Thank you, everybody.